So thank you so much, Helle, for the introduction. And it's a great pleasure to see so many of you, even if virtually. And as mentioned, I am going to present about the relation between scientific freedom and the right to science. So I'm just going to share my screen. Can everybody see it?
Yes.
Good. All right. So this was a project that was initially inspired by a report on artistic freedom, which was prepared for internal use by UNESCO. And whereas that was a report that contained an analysis of state responses to the annual monitoring survey for the implementation of the 1980 recommendation concerning the status of the artist, the aim of our report was to analyze the relationship between scientific freedom and the right to science. And given this subject matter, our ambition was to do so in a broadly scientific way. I'll therefore spend a few minutes in the beginning talking about our methodology before presenting the model of scientific freedom as a constitutive element of the right to science, which we arrived at. I will then describe how we used this model to contrast the provisions in the 2017 recommendation on science and scientific research with the recommendations we would have expected based on a theoretical understanding of scientific freedom which resulted from our work. But before all that, I want to note that this was very much a team effort that wouldn't have been possible without the hard work of all my co-authors, namely Maximilian Schmid of Kazana Europe, Peter Treit of the Max Planck Institute of Biochemistry, and Helle Porsdam of the University of Copenhagen. So as I already mentioned briefly, one of our ambitions in carrying out this work was to do so as scientifically as possible, given our subject matter. And for this reason, and because none of us started out as experts on the topic of scientific freedom, we adopted a technique commonly used in the medical sciences for the synthesis of evidence relating to a specific topic. Known as a systematic review, this methodology sets out in advance the search strategy to be used in finding source material, as well as criteria used to determine whether these works are relevant to the topic and should thus be included in the subsequent analysis. There were several reasons why we chose this strategy. By describing in detail and in advance the search strategy and inclusion criteria to be used, it becomes possible for readers to check or replicate our work by repeating the search using the parameters we describe. Most importantly, the systematic nature of the strategy enables the identification of all sources within predefined bounds which are germane to the topic, and thereby avoids the problem of conscious or unconscious bias in the selection, interpretation, and presentation of these sources. And finally, the information resulting from systematic reviews is considered to be the highest achievable standard of evidence for a given topic within the medical sciences. And although this is not yet commonly used in other areas of scholarly investigation, especially qualitative areas, the logic behind the use of systematic reviews is just as applicable elsewhere as it is in medicine. And so this slide sets out the stages of a systematic review. And we begin with the question in the top right. And for us, this was, what is the relationship between scientific freedom and the right to science? And to answer this question, we sought to identify an extensive and representative sample of articles and books on scientific freedom. So we started out with exploratory searches, which involve variations of the search term scientific and freedom. But because these resulted in tens of thousands of hits, many of which were only tangentially relevant, we later switched to a more targeted search syntax as shown here. So using these search terms, we identified more than 600 potentially relevant articles, which we compared against the inclusion and exclusion criteria listed in the middle and to the right of the screen. Any articles which met the inclusion criteria, but at the same time did not meet the exclusion criteria, were considered to be relevant and were therefore included. And this is what's known as a Prisma flowchart, and this visualizes the flow of information through the review process. And as you can see towards the bottom, in the end, we ended up with 80 articles and books that met our criteria and which we therefore included. So there were two reviewing authors, Maximilian Schmid and myself, and we split these articles and books in half, and each of us read the full text of the 40 articles multiple times and very carefully. And in addition to absorbing the general information in these articles, we also kept a lookout for specific recurring topics and themes and specific examples involving scientific freedom in real life, as it were, that were mentioned by the papers. And these examples, from these examples, we created a sort of database which we draw on in the report itself. And the hope here was that we could use concrete examples to assist in our understanding and the contextualization of the otherwise very theoretical discussions in the papers we included. We also kept a running tally of recurring themes, noting which papers mentioned which themes. And using this process, we identified 20 themes, which we grouped into 3 overarching categories that served as the organizing basis for the presentation of our results. Since there won't be enough time to go through all of these, I will focus on just a couple of themes that are most relevant to our present purposes, namely the justifications given for scientific freedom in the extant literature, its interpretation, and some of the tensions resulting from the characterization of scientific freedom as a constitutive element of the right to science. So if we stop to think about it, the idea of scientific freedom is really quite remarkable. In which other line of work do employees choose their own projects according to their whim and fancy, and then spend any number of dollars and months or years on it without much external oversight and no guarantee of success? These freedoms are rarely found in other professions, and so there must be something special about the pursuit of science which justifies greater freedoms. And in the articles we included, there were 3 main justifications. The oldest and most frequently mentioned justification for scientific freedom is that it is necessary for scientific progress. Many of the included studies rely quite heavily on this justification. Some considered it to be self-evident. To illustrate, Klaus Beitzer and colleagues wrote in a 2009 contribution that the crucial rationale for the protection of freedom of science must be seen to lie in the fact that it makes possible the discovery of the truth. Others pointed to historical examples of major scientific breakthroughs which would never have happened without the freedom to experiment with new techniques and methods. Wilhut, in a 2010 paper, noted that for this argument to succeed, it must only demonstrate a relative advantage of scientific freedom over other means of scientific organization in the diversity of research topics explored, under the assumption that the diversity of approaches taken when scientists enjoy freedom is the driving mechanism behind scientific development. When scientists are free to explore various methods of addressing a problem, he argues, it is likely that they will in fact make use of various methods in the face of competition to derive the benefits of being the first to solve a problem. Given that there are so many examples of scientific advances being made only after unorthodox means have been exhausted, orthodox means have been exhausted and unorthodox methods have been embraced, it would appear prudent to allow for as wide a variety of scientific approaches as possible. And scientific freedom is arguably the best way to achieve this, given the difficulty that other possible models of scientific management, like centralized control over research topics, face in obtaining the detailed knowledge of the skills, ideas, and interests of individual scientists and their ideal configuration into teams. Thus, decentralization at the level of the individual is plausibly thought to be more efficient than centralization at the level of national or regional science planning, and that is the essence of the epistemological argument for scientific freedom. Apart from its necessity in the pursuit of truth, we found 2 other major justifications for scientific freedom. The first was political. It begins by pointing out that scientific evidence is crucial for correctly understanding many politically sensitive issues, such as climate change and welfare policies. If there were quality information about the likely effects of various welfare policies, for example, people could weigh this information against their personal feelings on the matter, but at least these feelings would be scientifically informed. To achieve this, however, science must be free from political control. If science is not free from politics, there will always be an incentive to mess with the results in a way that favors a certain political angle on, in this case, welfare policies. And this is the justification that underlies the reasoning in the famous case of Sweesia, New Hampshire, of which judgment a part is quoted here. The other major plausible justification that came up was that scientific freedom is required by international human rights law. This is both directly and indirectly so. Article 15.3 of the International Covenant on Economic, Social, and Cultural Rights places obligations on states parties to the present covenant to undertake to respect the freedom indispensable for scientific research and creative activity. whereas Article 15.1b furthermore recognizes the right of everyone to enjoy the benefits of scientific progress and its applications, which we can abbreviate to the right to science. Note that the wording of Article 15.3, the freedom indispensable for scientific research, takes for granted the epistemic argument outlined above, namely that the justification of scientific freedom is that without it, science and technology will not progress. To the extent that this is so, the fact that everyone has a right to enjoy the benefits of that progress also places obligations on states parties to respect scientific freedom. Moreover, Article 15.2 explains that the steps to be undertaken to achieve a full realization of the right to science shall include those necessary for the conservation, the development, and the diffusion of science and culture. Thus, to fulfill this right, steps necessary for the conservation, the development, and the diffusion of science and culture must be undertaken, and insofar as scientific freedom is necessary for any of these components, states are obligated to include steps towards achieving its realization. Article 15.2 can therefore also be interpreted as requiring scientific freedom to the extent that the epistemological argument holds true. Where scientific freedom is necessary for the development of science, it is required by Article 15.2 as well. So the picture that emerged from the exercise of the literature review was one of scientific freedom as a necessary, but not a sufficient essential instrument towards the fulfillment of the broader right to science. According to this understanding, international human rights law places obligations on states parties to fulfill the right to science, and the way in which states meet these obligations is in large part through ensuring scientific freedom. Thus, scientific freedom might be called a constitutive element, that is, a necessary part of the right to science. In our report, we chose to focus our efforts on this conceptualization of scientific freedom for several reasons. Under this conception, the rules of the International Covenant and of international human rights law more generally will apply when one is attempting to interpret the various rights and responsibilities of scientists. This allows debates to be filled with a certain concreteness. Human rights law proceeds according to specified rules, with fundamental human rights principles and formal criteria for limitations on the enjoyment of rights. And this can be a great advantage for a topic otherwise as potentially hazy and difficult to evaluate as scientific freedom. So based on this understanding, we developed a test that can be used to assess whether policies or recommendations touching on scientific freedom are compliant with Article 15 obligations. And this test relies on widely used and commonly accepted tools of international human rights law interpretation, as well as on the provisions of relevant treaties, which here is the Vienna Convention on the Law of Treaties and the International Bill of Rights. And so the test and its derivation is described in much more detail in the publication cited here, but very briefly it can be summarized as follows. So, to the extent that scientific freedom is necessary for scientific progress, it is required by Article 15. And to be legitimate, any limitations on scientific freedom must therefore satisfy the limitation criteria for the International Covenant, which are contained in its Article 4. Taken together, these limitation criteria state that scientific freedom may only be limited, 1, according to the rule of law, 2, when strictly necessary to further the general well-being in a democratic society, and 3, when the limitation is compatible with the nature of the right to science and the nature of ICESCR rights more generally, which we operationally defined for the purposes of our report as a search for truth and the full development of human personality, respectively. To the extent that this is the correct interpretation, it will have serious implications for the kind of restrictions that governments can legally implement on scientific freedom without violating their human rights obligations, since few restrictions are likely to pass all 3 elements of the stringent test. Certainly, few of the examples of restrictions we found in the surveyed literature came even close to satisfying all 3 criteria. We then applied this model to the provisions contained in the 2017 recommendation. Both our model and the recommendation being human rights-based efforts, there was naturally a significant degree of overlap. We decided to focus on the few areas in which the recommendation included provisions which we would not have expected based on our interpretation of the model of scientific freedom as a constitutive element. One of these we considered to be quite a serious conflict, and the rest we classified as minor. So the most important point of divergence between human rights ideals and the provisions in the recommendation concerns the influence of a set of viewpoints centering on accountability, performance review, and the use of metrics and assessments in the assignment of research funding, employment, and merits. The fundamental criticism here is that this cluster of ideas values motivations such as economic gain as being equally worthy as the pursuit of truth in education, and that it makes unjustified assumptions about the benefits of scientific proposals, evaluating them according to the extent to which metrics can be applied to them, rather than their contributions to human knowledge. All of this makes it exceedingly hard to carry out the kind of blue skies, curiosity-driven research identified by the literature reviewed in our report as key to scientific progress, since such discoveries cannot be anticipated in grant applications or performance reviews. In addition, the requirement of performance review according to metrics and the realities of grant procurement divert a large proportion of scientific efforts towards essentially menial bureaucratic tasks. Therefore, the end effect of the application of this set of ideas to scientific management is a limitation of the right to science, which is neither strictly necessary for the general well-being, nor compatible with the nature of the right to science, and therefore has no place in a document such as the 2017 UNESCO recommendation. We also identified 6 additional areas in which the provisions in the recommendations were arguably in tension with the expectations, at least that we derive from our model. In 2 of these, the recommendation was too specific, mandating blanket policies of ethical and peer review, instead of confining them to the areas of science in which they are appropriate. So, ethical review is currently required for all human subjects research in many countries. Since review can take anywhere from months to years, this imposition necessarily involves opportunity and temporal costs, not to mention financial costs involved in obtaining consent, which translate directly into delays to research. And these in turn translate into lives not saved and illnesses not cured. Whereas few would doubt the necessity of ethical oversight for highly interventional procedures like chemo or radiotherapy, the costs do not necessarily outweigh the benefits for many other classes of research. For example, much of the social sciences research involves either routine surveys or interviews with human subjects, and epidemiological research carried out on pre-existing data is also considered to be human subjects research. Thus, the criticism can be made that it would be crass to subject, for example, a student project in which family members are asked about their interior design preferences to the same legal requirements as highly experimental and invasive neurosurgery protocols. Secondly, doubts may be raised as to whether ethics review boards are successful at their mandate. Studies that have compared identical or highly similar protocols have found extreme variability in ethical reviews. Although the idea of a multidisciplinary ethical review board is good, in practice, review boards are often made up largely of doctors and scientists, and very rarely does even a single member of the team have any formal education in clinical or research ethics or even in ethics at all. Often they are junior members that are volunteered to do the work, which is unpaid and is not typically taken into account for purposes of career progression. Finally, the observation has often been made that, at least in cultures with a heavy tradition of medical litigation, the de facto primary aim of institutional ethical review boards appears to be shielding their institutions from liability. Where this is the case, it results in a highly skewed appraisal of protocols in general and a disproportionate focus on consent forms in particular. So for all of these reasons, it would have been better if the recommendation had mandated ethical review only where necessary and where appropriate. So similar doubts exist in relation to the requirement of peer review, also mandated by the recommendation. As with ethical review, peer review inevitably introduces delays in the production and dissemination of useful research and typically involves unpaid junior researchers. It is also well known that the peer review system favors the publication of manuscripts which are an extension of or fit well within current scientific orthodoxy. The corollary of this is that the peer review system is biased against submissions which question such orthodoxy or introduce radically new ideas. Since these radical new ideas are often the ones that are most crucial to scientific advancement, peer review may introduce a bias that is not conducive to the progress of science generally. For these reasons, many scientists have moved on to other models of manuscript evaluation. Indeed, whole areas or fields of science, and most prominently maths and physics, though biology and medicine are also trending in this direction, have begun publishing manuscripts or preprints directly without peer review to online archives. In other cases, editor review and variations on peer review have been proposed and trialed. Now, the point here is not to argue in favor of or against any one of these evaluation models, nor against the idea of evaluation models as such. Rather, it is to point out that traditional peer review is not strictly necessary for the advancement of science, given the various problems associated with it and the viability of alternatives, and therefore it is not an appropriate item for the recommendation to impose without further ado onto the scientific community. We also identified 4 areas in which the recommendation appeared to us to be too vague, touching on important topics, but failing to disambiguate or detail the relevant provisions. Thus, the recommendation calls for, quote, balancing between protection of intellectual property rights and the open access and sharing of knowledge, unquote, but contains little in the way of concrete guidance to states as to what an appropriate balance would be. Since the underlying reasoning for intellectual property protection is in part to motivate scientific discoveries, these are surely compatible with the nature of the rights contained in the ICESCR and the right to science itself. However, nearly the entire extant right to science literature questions whether the current extent of protection is strictly necessary for the general well-being of society, arguing mostly that it is too high. Therefore, the recommendation should not recommend, from the point of view of scientific freedom, that states necessarily accept the current status quo. Another important area touched on too briefly is the distinction between positive and negative scientific freedom. Negative scientific freedom is essentially the freedom from outside interference into the choice and conduct of one's research. But true freedom to pursue important research requires much more than this. It requires funding, collaboration, scientific infrastructure, and education. The idea of positive scientific freedom refers to scientists' claim rights to these corollaries. The justification for scientific freedom, namely its necessity for the pursuit of truth, makes no distinction between positive and negative aspects, and therefore applies equally to both. The recommendation does contain a number of provisions relating to positive freedoms, but it does not contain any specific guidance as to the extent to which these should be promoted. Similarly, the recommendation touches briefly on the important topic of dual-use technology, but does not go into any more detail in explaining what it considers to be instances of acceptable restrictions on a dual-use basis, nor on who should determine what these are. Last but not least, the recommendation is insightful in drawing attention to the crucial importance of ensuring adequate scientific representation in the development of scientific policy and in the use of science in other policymaking, although it is unfortunately vague in emphasizing their specific importance to facilitating the development of policy which maximizes the pursuit and use of truth. The role of science and scientists in setting national and international policy is an important topic because so much of the policy space is directly influenced, or should be directly influenced, by science. Much of this policy space is also directly relevant to questions of freedom, in deciding which areas of research to consider dual use, which to prioritize for funding, which to ban outright and which to subsidize, and in setting educational and employment policy. In all these areas, policymakers directly influence factors relevant to scientific freedom. In most parts of the world, scientists are not prevented from working in policy or from advising those who do. They are not, as a whole, lacking the freedom from constraint in entering policy. However, the skill sets and methods of politicians are so different from those of scientists that the latter group may lack the positive freedom to influence policy. In other words, many scientists do not have the positive freedom to influence policy. Given the importance of having people who understand the scientific foundations and immediate implications of policy choices evaluate and help in the drafting process for the overall fitness for purpose of scientific policy and for the fitness for purpose of other policy with scientific foundations, it might be worthwhile, even from the perspective of scientific freedom alone, to facilitate such work. And this is quite simply because so many areas of policy have an impact on the scientific pipeline, and because so many areas of policy are legitimately informed by science, that failing to do so will likely have suboptimal consequences for the general well-being of society, and therefore be a legitimate target of intervention based on scientific freedom. So in summary, I want to emphasize that these last 4 points are not meant as a criticism of the document directly, but rather as pointing out areas in which the recommendation touches upon important points but could do more in providing concrete guidance to states and courts. The other 3 points of divergence, namely the requirements of peer, ethical, and performance review, are more worrying since they mandate practices which are likely in many instances to directly be counterproductive to the underlying goal of facilitating the pursuit of truth. Moreover, the specific critiques advanced here are necessarily based on a somewhat subjective assessment of what is and is not compatible with the pursuit of truth and the general well-being. Whether or not you agree with our application and interpretation of the model of scientific freedom as a constitutive element of the right to science, we hope to have convinced you that the model itself is a useful conceptual and operational tool for the assessment of the human rights compliance of policies and recommendations relating to science and scientific freedom. Thank you.